Welcome, I'm David Ricks. I'm a personal injury trial lawyer in Rancho Cucamonga and the principal of the Inland Empire Law Group. We handle a lot of personal injury cases here, and I often run into clients that will say to me, why do I have to prove my injuries? The other person was negligent. They caused the injuries I suffered. Well, the reason is because in California, we are not what's called a no-fault state. We are in a state that the person who's injured has the burden of proving that they were injured and that those injuries were caused by the negligence of the defendant. So basically, a person who's involved in a car accident, let's say it's a rear-end collision, first has to establish that the person who hit them was negligent. And that's generally pretty easy because if, let's say you're stopped on a freeway and someone comes in and hits the back of you, you would not be responsible for that accident. It would normally be the person who struck you. They're negligent. But then you have to prove two other things. The next thing is that that negligence or that accident caused your injury. So you have a causal connection. And then you have to prove the amount of the damages. A lot of people will try to claim a lot of damages when they're not hurt very much. And so the defense or the insurance companies or whoever you may be going against wants to make sure that they pay for only the damages that their insured caused or that the defendant caused. So in California, as a plaintiff, you have the burden, as the person that's injured, you have the burden of proving your injuries, the negligence of the other party, and that your injuries and your damages, or the money that you should be paid, was all caused by the negligence of that other person. So that's why in California, you as the injured person has the burden of proving your injuries.